Now let's talk about raising money from investors. This is a difficult area for you to do on your own. So anytime you bring somebody in, whether it's a passive investor or you're going out and actually raising capital, this involves a lot of complex laws, securities law, corporate law, tax law, a lot of areas that are a little bit much for someone to do on their own. And one of the biggest concerns is uh, the SEC and both state regulators oversee this area. Anytime you're bringing money in from someone that is not actively involved in your business, it's probably a securities offering covered by securities law, and you have to find exemptions and comply with the various regulations. Otherwise, number one, securities regulators could come after you potentially, or your investors if they're not happy with you, they have a legal cause of action against you for something called a right of rescission, meaning they can get all their money back plus interest and potentially fines or penalties or anything like that under state law that they might be entitled to. And it's the basis for a lawsuit against you. Even if you may not have done anything else wrong, maybe the project is doing well or a company's making money, they realize, hey, I want a reason to get out of this and get my money back. They now have a right and a way to do that in court. So anytime it comes to raising money or bringing capital into your business, you have to be very cautious. Anytime it's a silent partner, a passive investor, it's usually a securities offering covered by securities law. You usually want to hire a securities attorney to help you with that. It can be rather expensive. Depending on how much money you're raising, it could cost, a flat fee that we charge for a securities offering. Somebody raising a couple $1 million for a project is about $15,000 in a flat fee. Now you can get reimbursed out of the money that you raise to pay that legal fee, but it can cost you a fair amount of money to have that done. But you want to do it right because you got to protect yourself from potential liability. You don't want to get sued personally for doing something incorrectly. Now, if it's a matter of everyone is a passive investor, I'm sorry, everyone's actively involved in the business. You've got four people coming together. They're each putting 25 grand in. They're each having a role in the business and they're all active in the business. That you would just cover in a partnership agreement, LLC operating agreement. You want to cover things like what are your roles and rights, responsibilities? Do you have a title? How are you compensated? How are you splitting profits or losses of the business? These are all things that are covered in an operating agreement or partnership agreement. Whether it's, you create it yourself, which there are templates, and there's a resource in here on where you can find potential legal templates for things like a limited partnership agreement, operating agreement based on the state where you form your entity. So you want to make sure that you've covered that and put it in writing anytime you partner up with anyone to start a business. So if you're raising capital by doing that and everyone's active in the business, it might not be a securities offering. If everyone's actively involved, everyone has a role, they're all putting their capital in and all going to be active in the business. It might not be a securities offering, but otherwise it is probably a securities offering where you really should talk to someone who is an experienced securities law attorney to get an idea on putting that together properly, because there are disclosures like a private placement memorandum, securities filings with the SEC, a Form D often, blue sky filings, which are state filing fees. So it can get very complex, and that's one of my main areas that I deal in is securities law. And yeah, I mean, unless it's a very basic deal where you're raising money from people who are active in the business, otherwise you probably want to hire someone to help you out with that. And you want to look at a securities law attorney who's experienced in your specific area. So this is one of those that probably, unless it's a basic deal where everyone's actively putting their own money in and active in the business, in which case you should have a partnership agreement, operating agreement, something in writing, shareholders agreement that says what everyone's rights are, your voting rights, your management rights, your ownership rights, split of profits, can you transfer your shares or ownership, and how can you get out of the deal potentially if you want to, buy-sell provisions. These are all things you got to think about for a potential business divorce if you're all active in the business. If it's passive investors or silent partners, you probably should just talk to a securities law attorney.